Thank you all for coming. This is the first of the CPD Super Series here at Greenway Chambers. I'm Alistair Vincent, and I'm giving tonight's presentation together with Michael Swanson on comparative advertising and the Australian consumer law. Essentially just going through the recent litigation and recent developments in the law by reference to the cases, and then Michael will probably be giving a more practical analysis of things to look out for when conducting litigation of this kind. Comparative advertising has long been viewed by marketing experts as an effective and persuasive means of promoting goods and services. This is particularly so where claims are made of a scientific nature, as they recognise that such claims can have significant influence on the public and their buying patterns. Justice Foster, in the first instance decision of GSK and RB, essentially said that such advertising is usually cleverly constructed and aggressively and specifically compares two products while consistently reminding the consumer of the superiority of one over the other. The use of this advertising is widespread. We've all seen it, one product being better than another, and it is very effective. Due to its effective and persuasive nature, there are clear commercial imperatives for companies to seek to regulate such advertising, especially where claims are made to the detriment of their own products. And there's also a public interest from a regulator and also to the general public interest in ensuring that the claims that are made in advertising are accurate, especially when you're dealing with healthcare products and pharmaceutical products. It has long been held that claims of a scientific nature made in comparative advertising can only be maintained where there is a current adequate foundation in scientific knowledge for the claims. So just bear with me while I try and use this. The Justice Foster decision of GSK and RB is the 2016 Federal Court of Australia decision there. We'll come to that in due course. Clearly, when conducting these matters, the scientific knowledge and the scientific and how one proves the adequate foundation in science for a matter is the essential element of the claim. The principles are pretty general. They're very ephemeral kind of concepts as what's adequate, who knows. So therefore, really, the analysis is always focused upon the expert evidence in the cases. What does it mean for lawyers? Essentially, yes, we have to providing advice to clients, preparing matters for litigation, and also just settling and constructing the case by reference to the expert evidence. There have been recent litigation that I've been involved in the Federal Court of Australia, mostly as counsel for Reckitt Benckiser, for the producer of various Neurofen products and the like. Essentially in that over-the-counter pharmaceutical analgesic market, which is very lucrative, but also in the context of things as Reckitt Benckiser also manufactures Finnish dishwashing detergent products, and you'd be glad to know that I've now come to know full well how those things work, and indeed what the secret ingredients are in many of these tablets. The fundamental aspects of all claims revolve around the Australian consumer law. There's only 3 sections you really have to worry yourself about. Just to go back again, these are instances of the advertising. You can see the first one's the GSK and RB matter. That's Neurofen claiming superiority over paracetamol, but essentially Panadol. Strepfen and Diflam. Strepfen, the RB product, making claims in comparison to Diflam. This is the RB and AFT matter, of which there are 2 outstanding judgments, one before the full court of the Federal Court on appeal from Justice Gleeson, and then the matter went back again to Justice Gleeson on another matter, and Her Honour has also reserved judgment there. That's Hartley Atkinson, who's the creator and owner, as it were, of AFT, who puts himself in most of the advertisements because he obviously thinks he's very attractive. In all cases of this kind, well, first of all, let me go to the legislation. So the 3 sections, Section 18, the old Section 52, which everyone calls it, and I still do myself, misleading deceptive conduct aspect. And then there's also Sections 29 and 33, which just refine it in relation to Section 29, that you can't in trade and commerce or in connection with the supply or possible supply of goods or services, or in connection with the promotion by any means of the supply or use of goods or services, make a false or misleading representation. Essentially the same issues as Section 18. And then again, Section 33 is refined as to the manufacturing processes. You can't make a misleading statement there. But the issues are all the same. Essentially, it's just the misleading and deceptive conduct aspect, which is analysed by reference to whether or not there is a current foundation in scientific knowledge. When running a case, there's two issues. First of all, you look at the advertisement. Are the representations that you plead conveyed by the advertisement? That's where we get creative. What does it actually mean? Trying to, I guess, characterise or frame the representations as you can best do to assist your case, but by the same token, it's a matter for the judge just to assess the advertisement, normally on one or two viewings in any event, and then whether or not those representations are false, misleading, or likely to mislead or deceive. So there are a number of principles which are all recited consistently in the authorities. And the first thing to do when considering whether an advertisement is misleading or deceptive or likely to mislead or deceive is to ascertain the dominant message of the material. It's also necessary to view the conduct as a whole and in the proper context. The question whether conduct is misleading or deceptive or likely to mislead or deceive is a question of fact that must be determined in light of the relevant surrounding factors. I mean, they're all wonderful motherhood statements. What does it really mean? It means that the judge gets to make his or her own mind up as to what is conveyed by the advertisement. And ordinarily being a question of fact, it's very hard to appeal determinations of the existence of a representation. However, not impossible. Secondly, and following on from this point, while there may be occasions upon which the effect of otherwise misleading or deceptive conduct may be neutralised by an appropriate disclaimer, the usual asterisk, see below, the general rule is that a person engaging in misleading or deceptive conduct cannot use such a device to evade responsibility. So the court looks dimly upon attempts to essentially make a broad statement, but then try and subvert the meaning by saying, look at this qualification. So essentially, as concerns disclaimers, what you have to do is essentially look at the size. It does get down to assessments of how big the writing is and analysing what the font, the main message is in compared to what font the disclaimer is in, whether or not a consumer is likely to even make reference to the disclaimer, whether the disclaimer is on the same page or at the end. I mean, you hear those advertisements on radio with the very fast speaking people saying about terms and conditions and the like. It's the same kind of principles there. But essentially the question is, what is the message as a whole? What is being conveyed by this advertisement? And indeed, in National Exchange and Australian Securities Investments Commission, Justices Jacobson and Bennett held that a document which, read as a whole, is factually true and accurate may still be capable of being misleading if it contains a potentially misleading primary statement which is corrected elsewhere in the document, but without the reader's attention being adequately drawn to the correction. The principle which applies to these cases is that the qualifying material must be sufficiently prominent or conspicuous to prevent the primary statement from being misleading. Essentially, where there's disparity between the primary statement and the true position, it's essentially necessary for the maker of the statement to draw the attention of the reader to the correct position in a clear and prominent way. Again, all questions of fact as to how one interprets the advertisement. In assessing whether qualifying or additional material is sufficiently prominent or conspicuous, it is appropriate to consider not simply the words or images depicted, but also their relative emphasis and positioning on the page of the advertisement or in the television advertisement. Important matters will include the way the asterisk is placed, the size of the footnote relative to the text in the body of the advertisement, and the terms of the footnote. In the Tobacco Institute case, which was the Tobacco Institute of Australia and the Australian Federation of Consumer Organisations, 1992, the full court, Justice Hill specifically, held that where, as in that case, the advertisement is capable of more than one meaning, the question of whether the conduct of placing the advertisement in a newspaper is misleading or deceptive must be tested against each meaning which is reasonably open. That is perhaps another way of saying that the advertisement will be misleading or likely to mislead if any reasonable interpretation of it would lead a member of the class who can be expected to read it into error. So essentially the court is open to any reasonable interpretation of the advertisement. The Chief Justice, Justice Alsop in ACCC and Coles, adopted that passage and said himself, the courts should be astute and careful not to permit consumers to be misled on available meanings or connotations of phrases deliberately chosen to sell products on the basis that everyone takes advertising with a pinch of salt. He's on said, to place emphasis on advertising license that bends the truth will not only degrade the language, but lead to a culture of deception in the market. These matters do not elevate the case to a question of principle, but they should be borne in mind when broad laudatory language intended to affect the buying decisions of members of the public is such as to lead consumers into error and so to mislead or deceive. And the justification for such involves an intellectual shrug and a knowing nod to the effect that the public is cynical enough to look after itself. Essentially saying, you can't just say, as many lawyers do, well, I wouldn't take notice of that, or I don't really, everyone knows that that's just probably a lie. Doesn't matter. You have to be accurate. You cannot mislead or engage in conduct likely to mislead. Justice Lindgren in the Gillette litigation against Energizer, the 2002 decision of the full court again, talked about how the advertisements are to be interpreted. He said, I have carefully viewed the modified advertisement several times and tried to assess its likely effect on viewers. But as I observed in the earlier Eveready case, apart from the difference between a one-off viewing and repeated viewings, the circumstances in which a judge attends to a television commercial for the purposes of a case are not those in which the members of the public do so. First, members of the public watch a commercial after and before viewing other things, rather than isolation. Secondly, unlike the judge, they do not carefully view the commercial with a special interest in noting and memorising its features. Thirdly, they view the commercial not in the calm of chambers, but against the background of distractions such as domestic activity or simply a preoccupation with other more interesting or pressing concerns. Fourthly, usually they do not know in advance that the commercial is about to commence. So in assessing the likely effect the commercial would have on the viewing public, he's going to bear in mind the fact that the impressions conveyed and taken away are at once more and less than those conveyed by and taken away from a studied reading of the transcript. Essentially saying that a television commercial simultaneously stimulates the visual and auditory senses, and there are subtleties of suggestion not available from a reading of the transcript. And then coming then to how Justice Conti dealt with it in Reckerben, Keyser and Johnson and Sons, he said the following propositions are irrelevant. In identifying what may constitute conduct or relevant conduct, the packaging and advertising of the product must be viewed as a whole, rather than by endeavouring to ascertain in isolation the meaning of the critical words. It is the first impression conveyed by the packaging or other advertising which creates the impact on a reader or viewer, rather than an analysis of the constituent parts of the advertised message. And the whole of the message, the subject of a controversial promotion, should be considered in context. Thus, where a false dominant message is conveyed, its message will not be ameliorated by the accuracy with which may be derived from a careful analysis of all of the constituent parts of the whole. Most readers or viewers would not make a close study, for instance, of the subject packaging or television advertisement, but would absorb the general thrust thereof. And that's, of course, consistent with everyone's experience with advertising, and we're subjected to it constantly. And it's, in fact, the whole point of the advertising is to convey a dominant message. They want you to take into account only one message and one message only to take away, and because people can't remember more than one thing at a time most of the time. And so the courts recognise that by saying, well, you can't disclaim away from dominant messages. In terms of looking at the class to which representations are made, the Nike case, of course, the High Court held that where representations are seen to be directed to a particular class of persons, one has to ascertain what the likely effect on a reasonable member of that class is of the advertisement. The members of such a class are not always going to be homogeneous and may vary in education, intelligence, perception, time spent evaluating representation, distraction, or preoccupation by reason of such things as shopping for other items. And evanescent factors such as the attraction or interest generated by a way in which a representation is presented, much or all of which is likely to have been taken into account in designing the advertisements. So, the authorities are at pains to emphasise that there are no separate tests for comparative advertising. It's merely an application of the principles just previously stated in the context of a different form of advertising. So there is no separate test, although they then go on to state what the separate test is on one view. A comparative advertisement does not have to compare like with like. However, the comparison should be between actual competitors and competing products. A comparative advertisement need not compare all of the features of the products. You can be selective as to what you want to promote. Being compared that might be relevant to consumers in their purchasing decisions. It would be inconsistent with policy and objectives of the ACL to restrict a trader from publicising truthfully a feature of its product which is superior to the same feature of a competitor's product. Again, that just comes down to questions of fact and what the advertisement actually says. Ordinarily, when one is framing a claim, you try and frame the representation as broadly as possible because it gives you more grounds to allege its falsity by virtue of the fact that if a motherhood statement is made in relation to superiority on all grounds, then you only have to find one ground upon which the product is not superior to say that the representation is false. Whereas if the representation is very specific as to only a certain element of a product, then of course it may not be so easy to prove that the matter is false because that may be correct. Where claims are made of a scientific nature, it has been long held that there has to be an adequate foundation for these claims in scientific knowledge. In Janssen Pharmaceuticals and Pfizer, Justice Burchett held, of course, it is correct that the onus is on the applicant to prove that there is no adequate foundation. But it seems to me that proof that there is no scientific foundation for a statement in the realm of science may be sufficient proof that the statement is misleading. This will be so where, in its context, the statement must be, or is likely to be, taken as implying that there is an adequate foundation in scientific knowledge to enable it to be made. Again, just stopping there, the focus in His Honour's judgment there was on an utter lack of any kind of basis. It would be very rare nowadays for there to be no basis in science for a claim of a scientific nature. All the early cases seem to focus on the either mischaracterization of a study or rather than the evaluation of the study in terms of by analysis to other studies. In Sterling, Winthrop and Boots, Justice Tamerlan, in the context of an interlocutory application, held it can also, in my view, be misleading to make a statement which implies that there is an adequate foundation in scientific knowledge to justify it when taken in its context. A scientific statement quoted does not provide such a foundation. Doesn't really take it too much further. Justice Bennett and Johnson & Johnson and Unilever held Unilever has represented to the commuter that the preference exhibited by holiday skin users is supported by the use test. The study was silent as to the preference of holiday skin users under the age of 25, who represented a substantial portion of those users. The onus is on Johnson to establish that the representation was misleading. If Johnson establishes that there is no foundation in the study for a statement in the advertisements, that may be sufficient to prove that the statement is misleading. And as His Honour recognised, this is Justice Burchett, the question is whether the context in which the representation is made implies that adequate foundation exists for making it. Essentially, that was that element of having a test and saying that the test supports a statement that all users love a product, whereas in fact the test does not actually say that. Again, really these authorities are focusing on the fact that there is a lack of foundation at all. In the past, most matters seem to be litigated on an all or nothing basis. That is, the context as to the science was all one way. people just said the science doesn't prove that at all, or it does prove it in its entirety. There was a lack of analysis in the authorities as to what happens when there is a puddle of uncertainty, as it were, as to what the science is. Does the court have to evaluate it? What does it mean? If there are valid studies all both ways, does that of itself constitute a adequate foundation? In the Tobacco Institute case, the question was concerned an advertisement put forward by the Tobacco Institute, as it were, on the question of whether or not passive smoking caused disease, and essentially claims were made that it did not. The statement in the advertisement in that case that was under review was, "There is little evidence and none which proves scientifically that cigarette smoke causes disease in non-smokers." Essentially then Justice Hill, in his decision, made reference to two aspects of this case. He recognised that it's an all or nothing case. And he recognised that that puts the court in a very difficult position because they have to work out the science themselves. His Honour did say, though, that if the case was put on the basis that there's no adequate foundation in the sense that there's just no decision has been made, i.e. the science is still open on this question, that would have been sufficient to characterise the statements as misleading. Excuse me. So the first case I thought we'd look at tonight is the Neurofen and Panadol case, or Panadol and Neurofen case, depending on which party you want to read, which was a matter that was first heard before Justice Foster in the Federal Court of Australia. You can see that's an extract from the television advertisement that was run. That image and the graph was interpreted by GSK as a representation that Neurofen was saying that it was superior to paracetamol, and then also a representation that Neurofen was superior to Panadol because they led evidence that Panadol was the leading brand in the paracetamol market and therefore should be construed as such. Reckitt Benckiser, the manufacturer of Neurofen, essentially commenced advertising by virtue of this television advertisement in about August 2015. The other representations in the advertisement also touched upon the fact that they said that there was a scientific study published in 1996 which supported a claim to the effect that ibuprofen was superior to paracetamol in relieving pain caused by tension-type headaches. The fact that the study was published in 1996 did raise eyebrows with His Honour in the context of an advertisement in August 2015. Essentially, GSK then commenced the proceedings saying that there was no adequate foundation in scientific knowledge for a claim of superiority of ibuprofen over paracetamol. At the commencement of the proceedings, GSK sought to attack the actual study itself, saying that it was not accurate and could not be relied upon at all. That is the all or nothing thing. The science is out. There is nothing to support the claims at all. But by the conclusion of the trial and after the cross-examination of the various witnesses, the main argument of GSK was that the available Cochrane systemic reviews and meta-analyses found no statistically significant difference between ibuprofen at 400 milligrams over paracetamol at 1,000 milligrams. It's normally 2 tablets of each. In TTH, tension-type headaches, at 2 hours. Cochrane systematic reviews are essentially just a meta-analysis where they pull data from the various studies that fall within the terms of reference for the Cochrane studies themselves. Essentially, you get all the data, you put it into a washing machine, and you see what happens and comes out. What happened was that the study relied upon by RB was in fact called the Schachtel study. And the Schachtel study was found to be a reliable and good study, as it were. But after the Schachtel study, there were 2 further studies. Essentially the, NCT study and study NL9701. Very easy to remember names. Those studies, again, testing the effectiveness or efficacy rather of ibuprofen against paracetamol were not published studies. They were studies that were commenced but not concluded and did not result in any kind of publication whatsoever. However, the Cochrane reviews saw fit to include the data from those studies in their review. The Schachtel study found that ibuprofen was superior, but those two subsequent studies were inconclusive as to superiority. No study has ever found paracetamol to be superior to ibuprofen, ever. So that was the context in which the matter was run before His Honour. The experts in the case agreed that, in general, Cochrane systematic reviews and meta-analyses are a gold standard for evaluating and comparing medication and safety. The major Schachtel study results, being the single clinical study, provided, and this is what the experts agreed, and this is convincing evidence for the superiority of ibuprofen over paracetamol. Well-conducted systematic reviews and meta-analyses are generally more informative than single clinical trials as they synthesize the results from all relevant studies. So His Honour was faced with essentially one study that was found to be convincing evidence in the light of two studies which were inconclusive, but again, in the context of the meta-analyses, whilst the numbers in the meta-analyses showed there was a superiority in numbers or strength, i.e. the science tended towards a superiority of ibuprofen over paracetamol, it was not at the level of statistical significance sufficient enough to make a finding of that superiority. So His Honour found essentially that where the statement was that Neurofen is superior to paracetamol or Panadol, where the Cochrane review did not support that, that did not constitute an adequate foundation, and His Honour found for GSK. RB appealed about a day later, and the full court essentially just said, did what I consider to be, change the kind of emphasis on how these matters are reviewed. What they said is the judge is to take into account the totality of the scientific evidence available. So that is, you can look at everything. In fact, you do have to look at everything. Where the balance of the scientific evidence demonstrated no clear-cut superiority of an analgesic, a single study that does show superiority will not be sufficient to provide an adequate foundation to support representations of superiority. i.e., there has to be, if you're going to say you're better than something else, you have to have clear-cut superiority on the science. So if there's any wavering or any kind of puddle of uncertainty, as it were, the representation is false. Lastly, they held that the representations which carry with them an unqualified and definitive statement of scientific fact shall be misleading when the overall conclusion to be drawn from the scientific evidence was that no authoritative comparisons between active treatments were possible in the then state of scientific knowledge. So essentially, that is, it moves on from being an adequate foundation. Essentially, what you have to show now is clear-cut authority. So that's really the test at the moment. But in the context of what's your representation? If your representation is superiority for everything, then there has to be clear-cut. You have to demonstrate clear-cut superiority. It goes back to the question of what are you comparing? Are you comparing only elements of the products or the whole of the products? So essentially, previously there had been single studies that had been relied upon by some people to say, well, here's a valid single study. Nothing has gone against that. Why isn't it adequate? The court said, no, 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 no. It has to all, the science has to all go one way, essentially, right now. So essentially there has to be, and then the issues then come down to how do you frame the representations and how do you support those representations. So the next case then was Neuromol and maxi guzik. Oh, I'm going to go back. That was the Neuromol and maxi guzik compete in a combination analgesic market over the counter, but mostly behind the counter at chemists. Neuromol is and maxi guzik combine paracetamol and ibuprofen. And an advertising campaign in July 2017 from AFT made claims of superiority of maxi guzik over Neuromol. the court found essentially the difference between the two products was that if you took the full daily dose of maxi guzik, you got more of both of the monotherapies in the combined drug, namely the paracetamol and the ibuprofen, than you did if you took Neuromol alone. The court found that as concerns the claims of superiority of maxi guzik over the monotherapies, AFT did not rely on any other clinical study other than one study which it had commissioned previously to show any kind of superiority. What they did was just say, well, it makes sense. If you take more of the drug, it's got to be better. And they had expert evidence come in, and pain experts, give evidence of the fact that, in their opinion, that if you took more of the product, you got a better result, and therefore it had to be superior. But it was lacking scientific knowledge, lacking sufficient clinical studies to justify that. In circumstances where there were clinical studies out there that were inconclusive, once more, they went both ways. The court found that there was no adequate foundation. Essentially then, what has happened now is that AFT has appealed because they want to be able to say that essentially it makes sense that if you do take more, it is better for you. They ran the argument before the full court, essentially rehashing or focusing on the word adequate. What does adequate mean? The principles of adequacy do not mean completeness, as long as there is a basis that should be sufficient. It will be interesting to see what the full court says about that. So not only did they appeal, but AFT also saw fit to then go and commission another report, a clinical study, noting the complaints that had previously been made about the lack of a study. So in October 2018, following the decision of Justice Gleeson at first instance, and whilst on appeal, they published further advertisements, essentially to the effect that there is a new study that says that we're superior. So again, that matters before Her Honour is reserved. The arguments being that from RB that one swallow a summer does not make. Just because there's a new study doesn't change the entire playing field that in fact the court only decided upon a matter of months ago, and hence there's no adequate foundation. The next case is the matter of Finnish and Ferry. There are about 3 cases between Finnish and Ferry from about 2015 onwards. The most recent dispute was heard before Justice Lee, and His Honour handed down the decision last year on an interlocutory application from RB to restrain advertisements from Procter & Gamble, the manufacturers of Ferry. The advertisement was 15 seconds long. His Honour held that it was neither subtle nor multi-layered, and deconstructing it let me say this so properly again. His Honour found that the commercial lasts for 15 seconds. It is neither subtle nor multi-layered, and deconstructing it was like an early work of Ingmar Bergman and would be as unproductive as deconstructing that. Doing the best that His Honour could, he attempted to view the commercial through the prism of how it would be viewed by what he perceived to be the ordinary or reasonable member of the class of persons or the target audience who would likely view the commercial as an unbidden intrusion on their consciousness. RB pleaded 4 representations made in this advertisement. Essentially, the advertisement made claims as to the superiority of Ferry Platinum over the Finnish Quantum tablets at cleaning all stuck-on food. So RB pleaded rather specific representations as to the fact that superiority means that you say that Finnish does not require pre-rinsing, that somehow Finnish dishwashing tablets are faulty, that Ferry Platinum is better than Finnish Quantum at cleaning all stuck-on food. Ferry Platinum is superior to Finnish Quantum for all stuck-on food. The scientific evidence adduced by Procter & Gamble on the application indicated that Ferry Platinum was not better than Finnish Quantum as concerns all stuck-on food, but rather was more limited to starch and baked on pasta. The disclaimer in the advertisement made that classification. It said, we're superior for starch and baked on pasta. Of course, the representation that we sought to prove was that there was a more generalised statement of superiority for all things. Justice Lee rejected the representations as pleaded by RB, but found his own representation. His Honour's own representation was essentially Fairy Platinum cleans better than Finnish Quantum, but the representation conveyed when viewed contextually was in the context of cleaning stuck on food on the first wash. So what this decision shows really is that there is essentially it can come down to a matter of semantics. One would have thought that a finding by His Honour of a representation of Fairy Platinum cleaning better than Finnish Quantum in the context of stuck on food on the first wash is probably sufficient to include things beyond baked on pasta and starch, but to all stuck on food. But His Honour said no, he wasn't persuaded of that fact and hence dismissed the application. So the real issue is, how does one convey the representation? How does one plead the representation? And it's always a bit difficult because judges will always form their own view, which is based upon their own experience, of course, in life and how they want to view advertisements. But that's really the issues, the practical issues that have to be taken away from there. And the fact that if you get someone to watch the ad once more to assist in that, because once one's eyes are tired from watching a 15-second commercial about 20 times, it gets difficult to understand anything that's coming from it. I'm just about to hand over to Michael. Just saying, the last case was essentially Diflam and Strepfen. Again, the court was not persuaded as to the use of asterisks to carve out generalised statements of superiority. There was 2 asterisks used in that case. It was not held to be sufficient. Justice Bromwich determined that matter, which was again an interlocutory application only. Ordinarily, these matters normally settle once the interlocutory application has been resolved or determined, because essentially once you lose the impetus of advertising, if there's an injunction granted, the game's over. So it's very rare that matters go to full hearing unless the parties are particularly interested in doing so, which is, you see from the RB and AFT matters. Certainly one of those parties, who shall remain nameless, is very intent on continuing all litigation. So look, I'll leave there and I'll hand over to Michael to take on to the next part, which is essentially the more practical aspects of this area.
Thanks very much to Alistair. I think that's been an excellent overview of the relevant law, and I'm hoping to move substantially away from that because the cases were very long and difficult, and Alistair was in them, so he was much better at working them out than I am. And I've been reliably informed by the clerks that Chambers have actually had us tested before we came out here today, and Alistair is 16 times better a barrister than I am, but I'm slightly better at carrying books for senior counsel, so win some, you lose some. The important part of my presentation that I want to talk to you about today is how to explain your sciencey stuff to the judgy person. And the reason I title it this is because you got to pretend like you're 5 years old and you're talking to somebody who's 5 years old. So there are 2 elements to explaining your expert evidence and your scientific evidence to a court or to a person and all, really. The first is what we call the quantitative understanding, and these are the numbers and the outcomes that come out of it. You know, so you have an example that perhaps in Alistair's cases you've got 2 competing analgesics, pain relief medication. And the question is, well, how effective are they? And now one might kill pain for 6.75 hours if you take it at a 200 milligram dose, and the other one might kill pain for 4.38 hours if you take it at a 200 milligram dose. Now, to you and I sitting here, not having heard anything about what's happening here, that doesn't really mean much to us. But it is important to your case because that will always be why you win, because it will be the information that the judge relies upon when they write their decision, and those facts are key and important to it. But the reason that they will choose your evidence and to rely on and your evidence to follow is because you've built with them a qualitative understanding. That is, you've built with them a feeling and understanding that they get what is happening in the expert report. They kind of understand why things happen. They might not be able to work out the numbers themselves, but they've got a reasonably qualitative understanding that they get the quality of the information that you're giving to them. And that's important because that's how you convince them that you're right. The first one is why you're right. The second one is how you get them to believe that you're the right one. So for the first and quite potentially the only time in your legal career, Mr. Dennis Tenuto is your God. He is completely right, and his submissions to the High Court were absolutely flawless. It is entirely the vibe of the thing. It is the feel of how it is the feel of what is happening, and it is an understanding of how things affect each other rather than the exact numbers, how they do it. It's important when you attempt to approach this explanation that you're dealing with complex problems with simple explanations. And the reason you can do that is because you're not trying to give somebody a specific outcome. You're not trying to say this is where the threshold is on what we've got and why it is there. But you're trying to explain to them, well, if you push this value up a little bit, it gets disaster. And if you push it down a little bit, it's kind of pointless. So when in doubt, think about what Dennis Tenuto would say to the court, because he's done no work whatsoever apart from kind of vaguely looking at it beforehand. So the first example I want to use relates to three kind of objects. The first one's a balloon, because bladders look terrible on all the pictures on Google Images today, which is absolutely atrocious at finding them. But it's things that inflate. They're surprisingly common in both industrial and consumer products. They expand, they push things, they move. So it's quite common that they relate to the efficacy of a product or to its safety. The second one is a very cool looking engine block, and it offers on the similar principle that gases go in, they blow up, they expand at a certain rate, that pushes pistons out and gets the engine going. And again, it relates to the efficacy and the safety of the engine block that you've got in there. And the third is a first deodorant can that came up, and while less engaged in the comparative advertising side, it's a good example of product liability when you've got expanding gases and how everything works. So, what is the quantitative understanding of an expanding gas? Well, the first question is, how fast does it expand? Why is that relevant? What do I need to know? Your expert will tell you that. They are the ones who will know that. They will say to you, we have tested this in a lab. It expands at this rate in these certain conditions, this rate in these other certain conditions. This is the upper limit of what we can look at, and this is the lower limit. It's all very complex, and it is the reason why your case will get up if you are right. And it is the question you need to ask yourself there from your expert is, what are the limits for safe and useful gas expansion in these examples? And what are the values relevant to the case I'm making? Because they outline your case and they set up why your case is wrong, why your case is right. The qualitative understanding of that is, how do I best express these quantitative results? How do I communicate what's written down on here to the judge? And that's about working with your expert and finding out what is a useful way to convert what might be very impenetrable data into something that's very easy for them to read and understand. Importantly, what do my graphs look like? Unfortunately, pretty things look a lot better, but graphs and expressing data is important to how you understand that qualitative nature of it. What does it mean when I see this? What does this part of it mean? What does this look mean? So you have to ask yourself, what does it look like, and why is that important? The next one is, what do bad cases of these graphs look like? If I'm expressing my data as a graph and I'm saying this is the area that's okay, what does a bad one look like? Because you want a judge to be able to look at a graph that they get from somebody and say, oh, that shape looks very bad, I better check what that's like compared to the limits for it. And finally, describing what those differences mean. And that's much more of a qualitative exercise that you as the lawyers need to get out from your experts on the basis of how they prepare their report, the questions you ask them, and how you present that in submissions. So this is a quick example of a pressure time graph in relation to the expansion of gas. And I completely made this up. There's no real data in this. It's just numbers put into an Excel. The blue line in the middle is what we've called the actual expansion of the gas in our container. It looks pretty fine. You can see that everything's roughly in the middle of the graph. It goes up at a very pleasant rate, goes down at a very pleasant rate, and it all looks very lovely. The orange one is what we're going to call the upper limit. That is, this is the most rapid expansion and the highest pressure that the gas can reach in a container without exploding. This is usually what happens when gases expand quickly. And the grey one is what happens where it stops becoming useful. Where does it not expand quick enough for it to become useful? And kind of informing the person you're trying to convince about the different aspects of these kind of graphs are important. So you can see from each of the graphs has a peak, and that peak must represent something. So in the upper limit, it probably represents roughly where the container can operate within relative safety measures. The blue one, where it's operating, and the grey one, that peak there, anything underneath that probably stops being useful. And we can also tell how quickly gas not only expands in the container, but how quickly it escapes from the container, which is very important if you're trying to work out whether or not something's going to explode on you or whether it's going to fail to inflate at the right amount. So we have our data that we give to the judge. The judge sees something like this. We can explain some points to it for him. What we want to do, though, is we want to find the methods to explain those concepts to the person you're listening to. And that means picking out examples and features of them that they might not necessarily see themselves. As I'm about to show you, I'm going to show you two bad graphs. And it's important to show these to them because you want the judge to know exactly what a bad graph looks like. One, so if your graph needs to look good, it looks good. But two, if their graph looks bad, they know that it looks bad. And those feelings of good and bad are important in them understanding and appreciating the evidence that will come from your expert, which says, these are the limits, this crosses the threshold. The person reading it can then say, well, yes, that does look terrible, and that matches up with the number. You know, Mr. Swanson must be right, isn't he a wonderful and amazing genius? Frequently heard, I'm sure. And picking out those features is partly the job of your expert and partly the job of you in submissions. That is, the evidence has to come from your expert, but the way that you use them in submissions has to walk your judge through understanding what is happening, understanding why it is happening, and then understanding why you are right from the data. The best way I've found to do that is to relate the data to commonly understood experience or acts. That's things that you, I, or any punter on the street or a child will understand implicitly when you explain it to them because they're common features. So the first one we're going to look at is an underinflating graph. So this is where our graph is too flat. You can see generally they have substantially lower peaks than the good ones and the bad ones. They tend to be spread out a lot more. It looks flat, looks like a very pleasant ride on a bicycle compared to the rest of them. But it's important to explain to them what's happening here. So the elongated rise at the start indicates that there is a lower rate of expansion. That is, either your gas isn't getting in fast enough or it's not burning or exploding fast enough in there. And there's a slow decline, which means that it's not coming out very much, so it's sticking in there for a while. The example I'd use for something like this is a person first is slowly blowing up a balloon, and then there's a pinprick that goes into it that leaves a small hole with the air escaping very slowly. And you can see, you understand how a balloon works. So in your mind, you can picture, I get it, so the gas is leaving the cylinder at a very slow rate, not much is happening, it's pretty gentle. The next one is what happens when you have an explodey thing. That is, you get very high peaks. You can see that is above where our peak was before. That tends to mean that it's exceeded the capacity of the container to hold it in. It's got a sharp rise and a very sharp fall, which tend to indicate rapid expansion and then rapid exit from your container. And if you compare that to the idea of a pinhole going out, air escaping from a pinhole in a balloon, a rapid escape of air from a balloon tends to involve it popping very loudly straight in your face. But again, pick or apparently car engines exploding, which seems like a much more dramatic explanation than the balloon. But picking concepts that people can understand is important because you're dealing, in these kind of cases, you're invariably dealing with something very difficult and complex, but you want them to have a qualitative understanding of what that is, and the best way to do that is to relate it to something simple so they understand the concept for it and they can process it in relation to experiences that they've had, and then from that base you build on that with your expert evidence to explain to them what is happening in your specific case. And when you add the final layer onto that of the values that you have, you've established your case. They know what's happening, they know why it's happening, they've got your data and your quantitative understanding which says why you're right for it. The second one, so graphs are pretty easy because they're they're pictorial, everyone kind of understands what's happening, it's easy to follow lines and bars and trends. The next one, which is a bit harder, is dealing with things like mathematical formula. And often this involves calculations of some kind that are carried out by your experts, and I'm sure all of you have had expert evidence where sometimes they attach huge reams of data and calculations and you've never bothered to look at it, or it's just been impenetrable to understand. That's all going before the judge. If you put too much of that in front of them, it's difficult and they're never going to read it. But if you don't put any of that in front of them, in my opinion, they really don't get an understanding and a feel of what's happening. So it's important to build your case on the basis of what your expert is actually saying to them and why they're saying it to them. And sometimes that includes including mathematical formula that they're using, and it includes setting out their data and some of their data and calculations in the evidence themselves. The next example, we're going to look at free-range eggs, which has a voluntary definition, I'm told, of 15,000 layer hens per hectare, and it's not very good. It is actually appropriately described as chicken density, the density of chickens on a farm. This is actually one of the first things I ever did after I graduated from law school. Was I was asked to work on a matter where ASIC was suing our client because they said that your chicken density was too high. So surprisingly, it came up in real life, and it turns out ASIC terrible at maths. Unless they're watching this, and then you're wonderful. Chicken density is pretty easily calculated. You've got the number of chickens over the area of the chicken pen. Number of chickens is pretty easy to calculate. You count them up. It's the terrible task that you send the paralegal out to do. Count off every chicken to make sure you've got them all. The slightly more difficult aspect of this is the area of the chicken pen. And I'm going to pick something simple, but hopefully instructive, and that's we're going to have our pen is a big circle. So it's just a circular pen. Maybe there's a hutch in the middle. It's quite nice, but they can wander around anywhere they want. To determine the area of that, you have the formula. The area is equal to pi r squared. Pi is a mathematical constant, which I'm sure everybody's familiar with, and r is the radius of the circular pen. So r in this case, pi being a constant, is the only variable that affects the area of the chicken pen. And why is that relevant is because it's quite easy then to describe what happens to it. So if you look at the formula, it goes up at a rate of r squared. So I've written some examples down there. You take r equal to 1, r squared is equal to 2. R is 4, r squared is equal to 16. R is 8, r squared is equal to 64. So immediately what you can take from that is that if I increase the radius 8 times, that is from 1 to 8, r1, r squared is 1. For r8, r squared is 64. My pen is 64 times bigger when I increase the radius by 8. So I can have 64 times more chickens on there. The important part to take from that and to communicate to people is that the area goes up a lot quicker than the radius does. So any appreciable increase in your radius leads to a dramatically different and a dramatically increased area that you've got. Now, you approach a judge and you say to them, Your Honour, we had a pen. We were just under, so we increased it by 1 metre. It doesn't sound like very much to them. But if you've walked your judge through how the radius, in this case, how the area of a circle works, they know, oh, hang on a second, actually, every step up I go increases that by a lot. So when they go through and they read the expert report that says to them, well, they've increased it by 1 metre, and that's actually increased their area by 15 to 20%, and that puts them well under, that makes sense to them. They've got the data in front of them that says it, but they understand it because the concept behind this makes sense, that area gets bigger quickly while your radius only increases a little bit. And this works for pretty much anything you ever do with scientific evidence that involves calculations. If you write out a formula like that, it's pretty easy to pick a value in it, raise it, see what happens to everything else, and do that with each one. And it's a simple way to get a qualitative understanding of how these things work and how they affect your case. And if you can build on that and get the judge to understand what is happening, say, when you increase temperature in something or when you increase volume, it's much easier for them to accept and to trust the information you've given them that sets out, well, Your Honour, if a 3.4 degree increase in the gas inside your cylinder leads to an explosion because that increases the pressure by X amount, it's a much easier concept for them to understand if they've got some of those basics behind them. And so hopefully these are some practical tips about what you can get your expert to do. The first is to include in his or her report examples of their working. A lot of their working they won't do by hand, it won't be able to be produced, it might be done on a computer, but some of it that's instructive of what happens can be quite helpful because it lets the court and you understand what they are doing. And if you have that understanding, it's much easier for you to communicate that to somebody else. The second is include formula graphs and other methods of effectively describing data. That is, pick a way that you can describe the data and show the data to someone that they can firstly look at and easily read, but secondly, they get an understanding of what it's doing. So if you put in the formula like we did before, and you've taken them through a couple of examples, they can see why it increases quickly. If you put in the graphs and you show them what a graph that underinflates look like, and what a graph that explodes look like, very clearly they can look at them and say, well, yes, and I understand how the data matches up on that. So it builds into that second layer of their understanding and leads directly into your quantitative expert evidence. The third is pick your examples. Put in some hypotheticals as a way of explaining the theory about what's happening to develop that qualitative understanding. A judge might be sitting there and thinking, oh, this is very interesting, but what happened if I, tripled the temperature on this kind of thing? They get the idea. Temperature goes up, the time for your gas expanding goes up, the peak of the pressure goes up, and your canister explodes. Or what if I drop it? It doesn't go up quick enough, nothing happens, it peters out, and you don't get the expanding of your bladder like you'd hoped for. And the fourth one is explain these difficult concepts to the court. It's important that they get them. Judges are very smart people, but they aren't trained scientists, they aren't trained biochemists, they aren't trained pharmacists. You need to communicate that to them in a way, and your expert needs to in a way that they understand and they find persuasive. And finally, what can you do? The first is only minorly, shamelessly self-promotion, but that's work out when you need to find people to put in your team who know the topic area. Sometimes that means finding lawyers who do it, other times it means finding shadow experts who can come and just take you through and teach you all about it. But recognise when those people are important to your team. The third is base your submissions around this idea that first, if you have a qualitative understanding of what is happening, it's much easier to convince somebody why your numbers are correct. And finally, ask your experts to explain everything to you like a 5-year-old, because like me, you probably go into most of these matters never having heard anything about it before. And explaining something to you like you're a 5-year-old means that they pick simple answers, give you simple propositions, and they talk you through the things that they assume that everybody knows. Once you do that, you can develop your understanding, and then you can help them build the proper kind of expert report and expert evidence that will help you win your case when you are running. We like Neurofen better, do we? Neurofen, when you're representing Neurofen and trying to beat out Panadol for it. So thank you for listening to us. Are there any questions for either Alistair or I? Dramatic pause. Thank you very much for coming, and please come to the rest of the Super Series. I hear they're all wonderful. Thank you very much.